Good morning, everyone. You're watching Asked and Answered. Today we have the privilege of interviewing Darryl Stallworth, a criminal defense attorney practicing in Alameda County. But before we get on with the interview, if you like the series, if you like what you see, smash that like button and make sure you click subscribe. So let's get into it. So thank you for joining us this morning again, Mr. Stallworth. And the first thing is just want to know a little bit about your background. You know, what led you to the practice of law?
Well, I am a born and raised Compton native. And when I was growing up in the 60s and 70s, like a lot of young African-American men in Compton, I wanted to be a professional superstar, baseball, football, basketball, all those things. My parents required that if I'm going to play sports, I also had to do well in school. And I developed a discipline for practicing hard and also studying hard, which resulted in me doing pretty well in school. I finished high school, class valedictorian, student body president, and had a couple of options of where I could go to school, but I was not recruited necessarily to play football, but I decided to go to Cal because of its academic reputation. But before I started at Cal, I got a chance to do an externship at the Los Angeles District Attorney's Office, where I got some exposure to watching prosecutors try cases. I sat in on the Hillside Strangler case. It's pretty popular back in 1982. That sort of stuck with me. Later, when I was finishing up at Cal and I realized that although I had a good college football career, I was not going to make it to the NFL, I started thinking about law, and that planted the seed. Sometime later, after finishing at Cal, I worked for a law firm. I got encouraged from those partners that were there by the law school and said that I was going to go to law school, make a lot of money, go back to LA, live the good life. That's where it started. That's where the seed was planted.
I've read the first 30 pages. It's an easy read. I will definitely be finishing it by this afternoon. And it's impressive, especially the first part, the nuance just about statutory sex crimes. You know, something that you don't, no one's ever explained that to me the way that you have. So if you could just go ahead and talk about your book.
Sure. It started when I finished in law school and I decided to take the job at the Alameda County DA's office. My first assignment was reading cases and files and trying cases as a young prosecutor. And I started to read these similar scenarios of young people putting themselves in these volatile situations. Oftentimes the formula was drinking, bad decision, girl, or ego, bravo, fighting, all those things that were familiar to me growing up in Compton. But for the grace of God, there goes I. So I thought, I'm a prosecutor. I want to hold people accountable, but I also want to be proactive. I want to do some things that we can get this information out. And I started doing these crime prevention workshops. My first assignment in the DA's office was at the Berkeley office. So I managed to talk to some people who I knew in the athletic department, and we set up these workshops where I would go. Sometimes Terry Wiley, who was a guy who helped recruit me to the DA's office, a former Cal football player. We would go to the campus and just talk to the student athletes about DUIs, drugs, alcohol. And we wanted to do this in order to help get the information out. A lot of people who aren't lawyers, weren't working in the criminal justice system. They don't understand how severe the consequences are. They don't understand the damage that happens with one's reputation, particularly in these type of crimes. So the idea for me early in my career was knowledge, information, get it out there, help some people avoid going through the system. Soon after finishing a number of years in the DA's office and starting in private practice and doing criminal defense, I put together a series of TV spots. I had a little program on a local cable station called Staying Out of Jail. And I developed a series of 8 different areas of law that people should know about in order to stay out of jail. When I finished that and I start practicing some more, I continued the workshops, but I'd always wanted to sit down and write a book. This is more like an informational pamphlet. It's 56 pages, it's an easy read. It starts off with the scenarios that you have to be careful about, but also going through the elements of the crime, talking about the consequences, the damage to one's reputation, all the things you need to know. And I wanted to get it out there. I wanted to distribute it. When you get to this point of my career in almost 30 years, there's still a lot to do on the field and in the courtrooms, but there's so much more to be done with getting this information out. So that's a long answer to your short question. This book is a result of years of wanting to just get the knowledge out, hoping to get people informed so that they can avoid these situations. And if they happen to find themselves in this situation, this book can help you make some good decisions about what you do and what you don't do when you're being investigated.
And before I ask a follow-up question, let me just, I'm just cutting. Okay, so, and also, can you talk about, specifically the book is about sex crimes in the criminal justice system. And can you talk about some of the things that you'll learn, some of the nuances that, say, a new practitioner or someone who's learning about sex crimes, what are some of the things, the tidbits that they will learn when they read this book?
They will learn that at the foundational level of a sex crime, you have to understand that anyone who touches anybody else in a private area, whether it be under the clothing or on top of the clothing, if you do that without someone's consent, that is at a minimum a sexual battery. Oftentimes, middle schoolers, high schoolers find themselves in situations where they're horse playing and they are engaging in that conduct. There was a time where you would get called to the principal's office or you would get suspended. But now, because we are awakened in this new movement, these are criminal acts. And the painful journey of having your son and your daughter brought into a police department and being investigated for sexual battery, these are the things that the parents need to spend time with their young kids. I would start as early as possible, particularly with the young men, helping them understand that there are not only social and moral boundaries, but there are also boundaries that if you cross over, they become criminal. And no parent, no kid wants to be labeled as someone that committed sexual battery. So that's the beginning of walking through the fundamental levels of sexual crime, sexual battery. The other stage I then talk about is the statutory rape, which is a powerful term because the word rape is in there. It is sort of deceptive because statutory rape isn't actually your traditional rape. It's consensual sex with a minor. And a minor is any person who's under the age of 18. And I'm often asked, can a person who also is a minor be investigated and charged with statutory rape? And the answer is yes. A 17-year-old kid who's having consensual sex with a 16-year-old is having sex with a minor, and that is statutory rape. Now, we all know that it is rarely prosecuted, but I've had a number of cases, a number of clients where the parents have found this to be unacceptable behavior for someone to be having sex with their daughter, however consensual. And you can get charged, you can get arrested. It can be one of those really difficult journeys that this book, getting the information out, will hopefully encourage parents and family members to have these conversations. And nobody wants to talk about that, but you don't want to have that conversation while you are being investigated. You don't want to have it after you've had to retain someone to represent your kid. So those are the early stages that you have to be careful about. Of course, if you're over the age of 21 and you're having sex with a person that's under the age of 18, then that's felony statutory rape. And then you're talking about prison. You're talking about registering as a sex offender. And you're talking about pretty much eliminating any ideas you have about having any particular career, because your reputation, and that record's going to follow you, and it's going to be very damaging. Often folks don't understand and recognize that there's a lot of 22 and 23-year-old college young men who are having what they believe consensual relationships with some sophomore or junior in high school. That is statutory rape. That is a felony that could have very, very serious and dangerous repercussions. And then we move on to some of the heavier stuff. And this is the sort of traditional force and fear. You are in a relationship with someone, or you've just met someone, or you're having a casual date. And at some point in that relationship, at some point in the area where you're becoming physically intimate, you're making some decisions about what you think is consent. And where there is any fear or force involved, any struggle involved, those are going to be the clear, easy investigations. And those are going to be the ones where you're going to have a hard time being able to explain why and what was going on. The scary area, and the area that's in the gray area, and one of the main reasons why I wrote this book, is the other sexual assault, the other rape, the quiet one. This is the scenario where you're at a party or a graduation of some type of celebration. It could be a family event, it could be a school event, it could be somebody's getting a promotion at your job. Someone you know, someone you just met, someone you've known for a while, you find yourself developing a conversation, and next thing you know, you're at your home, her home, a hotel, parking lot, even a car, and you have sex. Turns out that you're probably a bit intoxicated, and the person you're having sex with may very well be extremely intoxicated, maybe under the influence of some type of narcotics, maybe suffering some type of serious mental impairment where he or she is unable to verbalize consent, unable to physically resist. And you, the person that's being investigated, has to be able to recognize that this is not a consensual situation. You are going to be required to know that any reasonable person in your position would have concluded that this person is incapable of giving consent. Although physically engaging with you, mentally unable to do so because of either the drugs, alcohol, or some type of mental impairment. This is the one that's happening over and over again because most folks don't understand and appreciate those elements and how you can be investigated, arrested, and charged. I could tell you, for hours the number of sad scenarios that I was a prosecutor for, and I've represented people who've been charged with these crimes. This book has a number of chapters that walks you through recognizing those environments and understanding that the days of the one-night stands are over, the days of picking up people in the bar, the days of casual sex. If you want to be able to have your freedom, if you want to be able to have a healthy life, if you want to avoid having to go through this criminal justice system, that is the red flag right there. I tell the young folks when I do these workshops, if you're not in a healthy, consensual partnership with someone that understands you and you develop a friendship and relationship, then you are vulnerable to finding yourself in these situations. So that's the general overview of the low-level sex crime all the way up to the more serious stuff that results in prison.